Welcome to Under the Basswood Tree podcast with Basswood Counsel. We break down the latest in tax law, cross-border deals, and M&A to help you build and scale your business with confidence. From international tax planning, developments in AI governance and regulations, to venture capital trends, each episode delivers focused insights you can use. Let's get started.
Welcome to another episode of Under the Basswood Tree. My name is Mugwagwa. Earlier this year, President Trump nominated Paul Atkins to become the chairman of the SEC, following the resignation of Gary Gensler after the change in administration. Mr. Atkins was confirmed by the Senate on April 9, 2025, by party line vote of 52 to 44. He was sworn in on April 21, 2025, as the 34th chairman of the Securities and Exchange Commission. My name is Mugwagwa, and I'm an attorney at Basswood Counsel's Corporate and Securities Practice. My practice areas include securities, private equity, venture capital, and also project and cross-border finance. Today, we're speaking with my colleague in the corporate practice, Jephte Lanthia. Jephte advises clients on corporate securities, regulatory compliance, and fintech blockchain-related transactions. Welcome, Jephte. So, Jephte, can you tell our audience here what kind of areas you practice in and your type of clients you advise?
The type of clients I advise are generally in the private fund space, fund managers, private equity fund managers, and also advise clients, some broker dealers, and some clients in the crypto blockchain space.
And where did you begin your legal career, Jephte?
I began my legal career in New York. I started right from law school. I was fortunate to have worked for a boutique firm in New York advising private equity and fund managers. So I was able to dive into drafting a PPM sub-agreement, et cetera, and advising clients from the fund formation process up until ongoing compliance. And during the crypto craze, I was advising clients on structuring token issuance. Clients who were issuing tokens, and some were actually wanting to trade tokens, and as you know, they would trigger whether they should register as an exchange. I've also advised clients from the other side, clients who were shareholders, like in shareholder litigations. So I've been able to see both sides of the transactions, as well as advising larger financial institutions. And most recently, prior to joining Basswood, most recently, I was a special counsel at the SEC.
That's fantastic, Jephte. And I think it's most appropriate today. We're talking about the SEC, your old place. So can you give us a quick background about the SEC and about Paul Atkins himself?
The SEC is the federal regulator that regulates the securities industry. And the SEC came about in the 30s. So you have to see that in the context of the crash, in 1929 crash. So prior to the SEC, many states had state licensing laws. And I think the first one was Kansas in 1911. Kansas, of all states, right? Sorry to my folks from Kansas. Then New York had the Martin Act. But those patchwork of blue skies laws did not cover everything. For example, some state laws would say, hey, you can have an offer of a securities, but the sale cannot be made in this state. So you had lawyers who tell the clients, hey, make the offer here, but make the completion, the consummation of the sale in a different state. So it has to trigger certain state laws. Again, mind you, there was before an actual federal law. Mm-hmm. And again, that lack of federal regulation led to some extent part of the stock market crash in 29. So that's why Section 5 of the 33 Act covers the offer and sale of securities. Mm. So again, the 33 Act, govern the sales of securities. The 34 Act, again, regulates, the exchange and ongoing compliance, once a issue of securities has been made. And so the mission of the SEC has three missions: investor protection, facilitate efficient markets, and facilitate capital formation.
And what role do then the commissioners play in the sort of that mission of the SEC? And then help us understand how Paul Atkins then plays an important role as the chairman of the commission.
Depending on who is the chairman, each one of those missions may have more weight.
Okay.
So again, because the chairman generally governs the policy for the year, the policy, the regulatory policy for the year. So, for example, we had Gensler. Gensler, his approach was more investor protection. So we had several rules that were geared, investor protection. With Paul Atkins, you will likely see somewhat of a more relaxed regulatory landscape.
So do we think, in your view, that the chairmanship of Mr. Atkins, we see this shift, as you said, from the Gensler-led commission that was led around investor protection and more, let's say, looking to be more enforceful of its rules and the like, that you see Atkins being maybe shifting the face more towards allowance, more permissiveness?
I won't use the term permissiveness. I would say probably more relaxed. For example, during his confirmation, his approach is more like clearer rules that factors the cost-benefit analysis of those rules. So basically, they would factor, hey, do we need rules that are so burdensome for the market? So I think his approach might be a little bit more towards a looser regulation, more relaxed, less likely I won't say less likely, more cautious with respect to certain enforcement, bringing certain enforcement.
Yeah, and I think we can see, as one would look in the market space and the like, is a potential thawing that we've experienced. Some might say maybe a new age of fraud taking us on as people feel that certain things won't be looked at. Because I think what we saw with the Gensler-Rang Commission, especially for the crypto industry, it seems the feedback from those in the industry, whether it's those offering tokens or those even investors wanting to participate in the market, they felt locked out. Do you think that at least the mood that you might find in the street that, we should see a more removed, less enforcement? Because we've seen announcements from the administration that suggest, suspension of things like the FCPA, which tends to rely on the SEC's analysis of books and records. Crypto, as we see more and more tokens being, or cases being settled related to token issuances or the classification of security, that potentially people feel that idea of cost benefit means it costs investor protection. Is that a fair assessment, or is that more people kind of taking extreme views of maybe more simplified, nuanced ideas?
I think people, depending on your politics, I think people are taking more nuanced, more nuanced ideas, like depending on your politics. Yes, the administration, sent out a memo asking the DOJ to pause on certain enforcements. And the administration also sent a letter regarding our view to crypto regulation. And so I think, again, you will see more clarity from the SEC. In fact, the SEC has the task force, which has been holding roundtable to have the market participant engage with the SEC. So you'll likely see more clarity on that. As you mentioned, the SEC had issued guidance on stable coins, guidance on meme coins. So you'll see more clarity on that. But I think, while there may be some reservation to pursue certain actions relating to, let's say, not registering, but you will still see action going on for fraud. So if it's actual fraud, well, again, it wasn't, hey, I forgot to register, Right. But if it's actual fraud, you will still see it. Again, there's the bread and butter of this is again going after fraudulent market participant. And having said that, just because that there may be like somewhat, for lack of a better word, of relaxed, regulatory landscape, I would also caution clients, don't take that for granted that, hey, I'm not going to register, I'm not going to do X, Y, Z, because the rules are still on the books.
Right.
And just because, they may not be, I guess, enforced, who knows?
Right. I think that, as we like to call it, prosecutorial discretion.
There you go.
Doesn't render the act unavailable. And how do you see, because the commission, although, we tend to speak of the commission, the chairman, obviously the commission has a mixed setup. What generally do people understand? Do you think people understand sort of sometimes the politics that exists within even the composition of the commission, that you tend to have, again, different administrations, but also there tends to be a balance in the commission. Can you maybe share some insights on the makeup of the commissioners on the SEC? Because again, there's the chairman is part of them, but there are other commissioners.
By law, the commission should have about five commissioners, and no more than 3 commissioners can be from one party. So if you have all 5, again, depending on which administration, again, which goes to the point that elections have consequences. So if you have all 5, you likely have like 2 Republicans, 2 Democrats, or vice versa. And as I mentioned, the chairman generally somewhat guides the policies. Now we have 4 commissioners, 1 Democrat. So if President Trump decides to nominate a commissioner, the person will have to be a Democrat. But at the same time, as we saw during the 90s, I think the commission had 2 commissioners at that point, and when President Clinton was slow to nominate. So again, it depends. But generally, with the commissioners decide, to bring like certain cases. What first they decide the policies, the rules. So they will tell if it's a rule relating to investment management, they will tell the Division of Investment Management, draft a rule X, Y, Z. So the division will draft it and send it to the commissioners, and they will vote whether or not this rule should be proposed, and then they will send the rules for comment, and then vote whether this rule should be adopted. And one thing that we are seeing now too, with the enforcement division, prior to the recent administration, the enforcement director had the discretion as to whether the division should initiate formal proceedings. And I think now there's a requirement that they have to submit that to the commissioners for voting, again, which means now the commissioners have more input into even not just filing civil cases, but even enforcement and investigations.
So even the initiation of investigations now has to have the direct oversight of the commissioners, potentially, again, influencing, as we say, given that there is a political composition to that there will be a political tinge to whether cases are investigated or even brought forward. I mean, even before we talk about filing a case in court. Now, what would you like to see, given that the chairman has such an important role in setting the agenda and essentially setting the tone? What would you like to see from the Atkins Commission, shall we call it?
To go back to support Atkins and some of the changes that we will see, I think we'll see. With IPOs, again, I mentioned IPOs.
Okay.
Right? So sometimes it's harder for small companies to go public because of the cost. As you know, you work on IPOs.
Yeah.
The cost of the compliance from the IPO process. So he's he's for having more streamlined rules to make the IPO process easier. And even after certain companies have gone public, the compliance costs of staying public, like for example, Sarbanes-Oxley.
Yeah.
Again, so again, there's the Job Act brought some relief, as well, for emerging growth companies like with 1.23 billion. They also do like a scale disclosure, right. But again, it's still a cost. And going back to the earlier point, I think again when you talk about Sarbanes-Oxley, again, it's not a bad law. It's a good law, and we talk about in light of Enron.
Right.
Enron, we saw in Enron the accounting failure. So you need laws to respond to, not just
you can
to foresee. still foresee certain market failures. But at the same time, there should be then balance where, again, it's not stifling the market.
Right. It's a balance, as you say, right? You try to respond to the last crisis. You don't waste crises, but also you have to think consequences only sometimes exhibit much later on. Now, when we think about that, interesting around the IPO issues, I think there is quite a conversation happening about the lack of IPOs, especially in the U.S. in the past year or so since the Fed. There's an issue about staying public companies as well. There's quite a movement, or at least an expectation in the market, that being a public company might not be the most productive way to operate, which has its consequences that there's a limitation of access if companies are not public, but also we realize that there's a lot of private capital available. So one of the reasons people go public is to raise capital to build the machinery, but it's been less so. And I guess that part of what the commissioner will have as part of his challenge is really being able to address the issue of, you have a market function issue, but then there's the compliance side of it. But if people don't need the capital per se, he'll continue limiting. And maybe it's really the smaller companies that need capital. Do you see any of the opportunities there for clients to think about where maybe the smaller companies are not having access to capital versus the bigger companies who have a lot of private capital available? They never have to go public.
And to the point about the private market, that's why we had so many unicorns. So again, companies like small companies that were worth $1 billion, right? Mm-hmm. So it's kind of, why go through the hassle of being a public company? Again, the point of being, one of the benefits of being a public company is the status, mm-hmm. right? And the access to capital, access to retail investors, right? You've done the whole, restrictions, so nice, easier to, access the market. Mm. But if I can get that capital through private market, I'm not going to go through the hassle mm-hmm. of being a public company. But that's assuming, again, I have access to that.
Correct.
So, private capital. So if I don't, then I'm back to, again, what I have to, either consider the cost of IPO, et cetera. And unfortunately, going back to the cost by being a public company, and to your point about politics, depending on where you stand, rules regarding, let's say, disclosure, ESG. Again, I don't have one another, right?
Right.
Again, you have one. Some people may think, hey, those rules are not necessarily, they're a burden for public companies. So climate disclosure, et cetera. So I think again, what I want to say, I guess more sensible, practical approach. But I think what my clients would want to see again, the more ways for companies to go public, mm-hmm. right? It's one more clarity, mm-hmm. more clarity relating to cryptocurrency, and I think again we'll see that again, given again the task force and given what Chairman Atkins said during the confirmation, and what I see too, in the emerging fund manager space, change the rules to allow venture capital, right? Qualifying venture capital to be able to have more than 10 million, right? So for example, if someone has a structure of a qualifying venture capital, they can only have 10 million in commitment. So therefore, if I have this fund, I cannot go to a large institution asking for investment, because they may say, hey, we don't invest less than 10. We don't invest, it doesn't worth the hassle of going through the legal work. Right. So they're not going to bother. They may not bother investing, in a smart emerging fund. Similarly, change the rules, where funds can invest in other funds, like venture capital fund can invest in other venture capital funds, and also adapt the rules where a quality fund can have more than, let's say, 100. Right? Again, I'm mentioning that against the backdrop of venture capital funds, emerging fund managers, they're the lifeline of capital to small businesses. And as we know, small businesses the lifeline to generate jobs.
Right.
So I think again, although some of those changes are statutory,
Right.
whereas Congress would make the change. But I guess if this is showing appetite, so maybe
they could guide.
Yeah.
I guess the commissioners can take their desires to Congress to say, look, we would like to, because I think it's I think it's insightful because maybe there is a stratification that's happening intentionally or otherwise that those this private capital that you would think maybe goes to small businesses because they cannot overcome the hurdle of IPO process, the cost of an IPO, right? Which now is probably north of $1 million if you think about it. But in fact, it's those large companies that are benefiting most from private capital. And actually, the smaller companies are somewhat ignored, but they also have no possibility of accessing the public markets because they're not of size yet.
Yes.
How do you also see within that context that those small businesses, they probably are well known in their community, understood within their markets, and people would like to invest in their small businesses. Do you see any action coming around this issue of, we know very much so that the accredited investor moniker is very important for private capital because they get the ability to raise capital from them is very different from the quote unquote public investment market. But do you see potential there that that could help this process? And would this commission potentially look to do something around accredited rules?
I would want to see it. I would love to see it. And again, for those of you, I'm sure audience probably know, but for those of you who know, like in the accredited investor definition, right? 200,000 salary, 300,000, with your spouse, and 1 million net worth, excluding your primary residence.
Right.
so that matters too, right?
Asset.
Excluding it. Yeah. That limits a whole swath of people. I mean, again, we're talking about 200K. Then that limits a whole bunch of people to folks who have access to investment. And that definition, I think, came around in the 80s, 82, when the SEC adopted Reg D. And it's almost, I guess, I would say arbitrary, because on the one hand is the assumption that, hey, if you meet a definition, you are able to fend for yourself.
Okay.
Right?
So it's about being able to withstand it.
Fend for yourself.
Okay. So are your thoughts that since this was not a number established based on, okay, if somebody earns this much money, they should be able to fend from themselves, address the thing. Do you think that, given things like inflation, that they actually should update that number to be higher?
I hope not.
Okay.
I don't think it has been adjusted for inflation, because I think last time I checked, if it were to be adjusted for inflation, it would be like 500,000, I think.
Okay.
We're talking about the 80s. So,
right. Yeah. Right.
Yeah. So I hope that, if anything, I think as far as amending the definition, even if they keep the income requirement and net worth requirement, there should be other ways where someone can meet that definition. A couple of years ago, 2020, the SEC issued the concept where they modernized the definition of accredited investors to include professionals with Series 67, Series 65, I think Series 83 licenses. As you know, those licenses are issued through by association with FINRA.
Correct.
And again, yes, I think that kind of opens the market a little bit for some folks, but not a lot. Again, as you know, again, you can have a lawyer, a first-year associate, and a second-year, third-year associate at a mid-sized firm who's not making quite 200, but has enough experience or knowledge to understand investment. So that person, I would think, is reasonably assumed able to fend for himself. And again, you can have someone who actually works with a broker dealer, but they may not have the licenses. Those persons are probably sophisticated enough to understand risky investment. And on the flip side, you tell me a 22 years old kid who probably has money, right?
Yeah, I mean, if you got drafted, if somebody got drafted in the first round this year, they're gonna have the income. So they're a qualified accredited investor. However, you have. I mean, I remember for myself as I realized, my first 2 years of practicing that I didn't, I could advise on these matters, but I can't invest on the matters I'm advising. Whereas, as you say, even a high schooler, right? If you think about, they have to be of age of contract. So an 18-year-old NBA player is considered a accredited investor who can fend for themselves. I guess you could say from an income perspective, financial loss, maybe they can withstand their investment, maybe not. But from a knowledge and access, because I think one of the key things maybe attention that maybe the Atkins Commission can help us work through is attention of knowledge and experience versus maybe using a financial number reference as a basis for what is the market, right? We focus on disclosure and understanding the information to make an informed decision versus I can withstand a loss. So there's a natural tension.
Definitely.
Exists there, right?
And before I pick up on that, it's like, like some people have said, hey, the accredited investor definition is meant to, on one hand, whether someone can withstand a loss, but it is somewhat materialistic, right? Like you telling me what to do with the money. Again, it's good. We need regulators.
Right.
We need regulators to event. Again, to some extent, that's why we have the FTC, right?
Right.
If I decide to spend $10,000 on a bag that I cannot afford, but I have the money to spend it, right? That's my choice. Now, to the extent that that bag is a fake, then that's where the FTC would come. Hey, this is the FTC or your state AGs.
Right.
This is again a fraud issue. So I think a lot of times it is that whether it is to prevent fraud or is it to actually prevent to protect investors from doing investment. But I think overall, I mean, especially now people have more access to information. People are somewhat more savvy. So I think they should be able to make certain investment. Although, again, the commission has taken steps towards that. I mentioned, the licenses and FINRA, the crowdfunding rules allow non-accredited investors to invest at certain amounts. So there is some, approach to allowing non-accredited investors to participate more in the investment process. But like I said, I think we can do more, whether it's, again, certification from a FINRA, a school, somebody, again, so more people can get into the market and businesses can have more access to capital.
And I guess it would be interesting. I think the take could be, we've seen what's happened. If you look at the amount of investing that's happened or people entering markets in certain ways, like, I think we're part of the support for where the enthusiasm for crypto had been. It's almost a desire and appetite for investment, but having to do it in a way maybe that's out of the purview of regulators. And maybe the opportunity will be for the Atkins Commission to tap into that, to bring it to more, let's say, productive investment into companies rather than code. And that maybe that's an opportunity that people have an enthusiasm and providing them an opportunity where they do it in a maybe sort of safer, because one of the things that I think will be interesting to see is there a trade-off made to say, maybe we relax the accredited investor, the registration aspects of the structure we have, right? Because it all starts with registration or exemption from registration, that maybe the commission will say, we relax your ability to do private fundraising, but we become more vigilant about exercising the thing that's always there, 10b-5, fraud in the securities, because if you have enforcement against fraud, you're protecting people, you're protecting the sanctity of the market. So maybe that will be the trade-off and something for us to look forward to in the Atkins era, again, his reign as commissioner, chairman of the commission. And Jephte, I don't know if there's anything else you wanted to touch before we call time on this and look forward to the Atkins first takes in his first 100 days.
Well, let's not call time. We have plenty of time. We can talk about this all day.
Right.
But one thing with the Atkins Commission, what we like to see in the private fund space. Again, as we know, Chairman Gensler had several rules that affected the private fund. The private fund advisory rule required fund advisors to issue a fairness opinion in secondaries, quality statements. So the compliance costs, required under the private fund rules. The market was very. To the extent that they sued. Okay,
right.
Well, yeah, the rule passed and they sued, right? And the Fifth Circuit actually stopped the rule.
Right.
So I don't foresee any appetite from the Gensler, not from the Atkins Commission to appeal, and I don't foresee that one because again, having said everything that we said, but during his confirmation, when they asked him, hey, do you think the investors in the private markets, private funds need more disclosures regarding fees,
right?
Fees and expenses? And I think his response was, those investors are sophisticated enough to understand those investment, and there are other rules already in place to protect private fund investors. So in the private fund space, I don't foresee again any rules that would stifle that market. In fact, with the recent no action letter that allows issuers to raise under 506C and making general solicitation, provided they have certain requirements, certain minimum requirements, and that's really going to open the door for private funds.
So more money again back to private funds, and they're now able to publicly advertise and not have to go through an onerous verification process. So again, it's more to the privates potentially, but again, maybe gives the commission a reason to push more on the IPOs, bringing back market rights.
But having said that, though, I would say that if we're to amend the accredited investment definition, then the question is do those investors? I guess it's like how you balance that with respect to private funds. I mean, there's an argument that non-accredited investors who invest with accredited investors in private funds, they get the benefit of the experience, the experience that accredited investors, bring along. But there's the best way, can they, so I guess you have to balance. Okay, well, if you are going to loosen the accredited investment definition, again, how does it work? How will it work with private funds? Where so I think again, there's the balance I would want to see.
Okay. Well, thank you, Jephte. This has been an enlightening topic, and we're certainly looking forward to see what the incoming SEC chairman really delivers for us in the markets. And for those listening, please, reach out to us via the web through our services and contact us, or contact Jephte or myself directly to speak to our team if you have any questions around securities matters, private funds, venture capital, or private equity. Thank you again, Jephte, and we'll see you the next time.
Thank you.
We hope you enjoyed this episode. To stay up to date with the latest legal insights and Basswood events, please follow us on our Basswood Counsel LinkedIn page and visit our website at www.basswoodcounsel.com. Thanks for tuning in, and we'll speak to you next time.